Bentar ini. Prof, mohon izin Prof. Halo Prof. Prof Khairuddin.
Oh, sorry. Gimana?
Pak Khairuddin, kita
Ya, Prof.
bisa mulai ya?
Ayo.
Mohon izin Bu Rektor. Bu Rektor, mohon izin.
Ya, Pak Dekan, silakan.
Ya, mohon izin Bu. Silakan Bu Haliah. Ini kita kerjasama dengan Asosiasi Hukum Keluarga, Bu. Dosen Hukum Keluarga ini. Ada Prof Khairuddin ini.
Oh ya, selamat pagi, Prof. Khairuddin.
Selamat pagi, Bu Rektor.
Iya, ini Prof Kris sudah nyambung ya?
Alhamdulillah.
Mohon izin kita mulai, Bu ya.
Monggo.
Ya, Bu Alia, silakan Bu Alia.
Halo,
Halo,
tidak kedengaran ya Pak?
Bu Alia sudah bisa?
Ya. Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam warahmatullahi wabarakatuh.
Alhamdulillahilladzi an'amna bi ni'matil iman wal islam. Wassalatu wassalamu ala Rasulillah sallallahu alaihi wasallam wa ala alihi wa ashabihi ajma'in. Amma ba'd. Respectable the head of Asosiasi Dosen Hukum Keluarga Indonesia, Mr. Profesor Dr. Khairuddin Nasir MA, the respectable Rector of Universitas Pembangunan Nasional Veteran, Mrs. Dr. Erna Hernawati CPMA CA, and the honorable all of audience. On the special morning, we have agenda on International Conference on Family Law, Contemporary Issues on Family Law, Various Perspectives, Faculty of Law, Universitas Pembangunan Nasional Veteran, collaboration with Association of Islamic Family Law Lecturer, Asosiasi dan Hukum Keluarga Indonesia. Welcome to the National Conference on Family Law opening. On this special morning, we have several agenda, so allow me to read several sequences of our agenda. The first is opening. Let's start this agenda by reciting Basmalah together.
Bismillahirrahmanirrahim.
Ladies and gentlemen, step on the following agenda is reciting the Holy Quran, who will be recited by our sister, Dr. Nur Nazli MAG SAG SA. Times is yours.
Assalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam warahmatullahi wabarakatuh.
A'udzu billahi minasyaitonir rajim. Bismillahirrahmanirrahim. Wa antum nisa فإن طبنا لكم عن شيء منه نفسا هنيئا مريئا. ولا تؤتوا السفهاء أموالكم التي جعل الله لكم قياما. التي جعل الله لكم قياما وارزقوهم فيها واكسوهم وقولوا لهم وارزقوهم فيها واكسوهم وقولوا لهم قولا معروفا. فإن آنستم منهم رشدا فادفعوا إليهم أموالهم ولا تأكلوها إسرافا وبدارا أن يكبروا ومن كان غنيا فليستعفف ومن كان فقيرا فليأكل بالمعروف. فإذا دفعتم إليهم أموالهم فأشهدوا عليهم وكفى بالله حسيبا. صدق الله العظيم. Assalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam warahmatullahi wabarakatuh. Thank you. Excellencies, ladies and gentlemen, we are going to the third agenda is singing Indonesia Raya and Bela Negara.
No.
The Honorable ladies and gentlemen, step on the following agenda are speeches. The first is welcoming speech from the leader of Association of Islamic Family Law Lecturer, ADHKI Indonesia, Mr. Prof. Dr. Haji Khairuddin Nasution MA. Time is yours.
Baik, suara saya kedengaran? Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam.
Alhamdulillah, wassalatu wassalamu ala rasulillah wa ala alihi wa sahbihi wa mawalah, la hawla wa la quwata illa billah. Asyhadu an la ilaha illallah wa asyhadu anna Muhammadan abduhu wa rasuluh la nabiyya ba'da amma ba'du. Thanks to God for His mercy, possible us to join for this international conference this morning and until tomorrow, inshallah. And greeting to the Prophet Muhammad sallallahu alaihi wasallam, who show us the right way by which hopefully we'll save here and hereafter. Honorable Rector, Vice Rector, Dean, Vice Dean, and all staff from Universitas Pembangunan Nasional Veteran Jakarta, especially Dean of Faculty of Law, Dr. Abdul Halim, and all committees from UPN. Distinguished speakers and all session speakers and all participants who can join us for this conference. This internal conference with International Conference on Family Law, contemporary issues on family law Paris perspective is possible under the collaboration in Association of Islamic Family Law Lecturer ADHKI Indonesia with UPN, Universitas Pembangunan Nasional Veteran, especially under the Faculty of Law. So, first of all, I would like to thanks to the Rector, Ibu Dr. Erna Hernawati, AK CPMA NCA, and also especially to the all committee from UPN Jakarta. And secondly, also, I'd like to thank to all speakers, distinguished speakers from Ibu Dewi Arianti, MA, Dr. Christopher Keson, Stin Maidai, and Iwan Darul Yusuf, Arika Asika. And of course, also thanks to the session participants, who speakers from all UIN EIN throughout Indonesia. And of course, also I'd like to thanks to the participants who can join us for this conference. And of course, the objective of this conference is really a kind of a part of implication of our job as a lecturer by using the system law. We are as a legal structure who responsible that the law is applicable and used by the family in their life, in day-to-day life. So, theoretically speaking, that the smart state based on or start it from the family. So, if you want to be a smart state, just build a smart family. It means the family is become main factors to be state, either a smart state or horror state. So then family is a key word, a key system, a key factors to be a smart state. So our job as lecturers is how can we socialize to the people? The law to make smart family. And we believe that Islam has equal right and equal law between wife and husband, as also argued by some seculars based on Al-Quran and Hadith. In fact, that the ultimate joy, the ultimate objective of family is sakinah, is happy family. To be have a family, happy life, one factor has to be based on the way we say that the equal relationship. Another way to say that equal right, equal relationship, and equal things of life in the family. And in fact, now what's happening in our society is still the relationship based on still inferior and superior. So then our responsibility just tell us to socialize by using the theory of the construction society, that from the extension to externalization, means that, so by this we write and then we express in this conference. May some people listen to us, maybe some only listen, but some maybe they think about, some others maybe they consider to be thing, and then we retain their habit, their habit in their family. And after that, the result of this conference we try to publish, and hopefully more people read our paper. So hope by expression in this conference, by reading and publish, will more people read the idea, so that family has to be based on the equal family. So by this way, say that then the more we write, the more we speak, the more we publish, hopefully the faster the change will be from the superior inferior relationship to be equal relationship. So we hope that this conference will contribute to this. So what we write, what we say, what we publish, hopefully will be contribute to the change of the society from the superior and inferior relationship to equal relationship. So that's, I think, so it is comprehended. So I hope, and would like to Ibu Rector open this conference officially. So on behalf of ADHKI, all committee and all the lecturers from ADHKI, thanks again to the UPN who joined with us to do this conference, to make this conference possible. So thank you very much, and Assalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam
warahmatullahi wabarakatuh.
Thank you to Mr. Professor Dr. Khairuddin Nasution, MA, the leader of Association of Islamic Family Law Lecturer, ADHKI Indonesia. Excellencies, ladies and gentlemen, the second speech will be delivered by Rector of Universitas Pembangunan Nasional Veteran Jakarta, Mrs. Dr. Erna Hernawati, AK CPM ACA. Please, time is yours.
Thank you, Ms. Halia. The Honorable Professor Dr. Khairuddin Nasution, MA, as Chairman of ADHKI Indonesia. The Honorable all speaker, Dr. Christopher Geshen, Professor Arya Nakisa from University of Washington, Ibu Dwi Arianti Ramadhani and Dr. Iwan Erar, and my colleague, the Dean of Faculty of Law, Bapak Dr. Abdul Halim and all staff, Vice Rector, and all participants. Assalamualaikum warahmatullahi wabarakatuh. Good morning all. Praise be to Allah Subhanahu wa Ta'ala, Almighty God, for His peace and His grace, that today we can still gather in this event, even though in the COVID-19 pandemic. Hopefully this condition will soon be better, and then we can live normally again. Amin, amin, ya Rabbal Alamin. This event, international conference on family law, who initiated by Faculty of Law, Universitas Pembangunan Nasional Veteran Jakarta, collaboration with Association of Islamic Family Law Lecturer, ADHKI Indonesia. I think it's become very useful with the presence of all excellent speakers, and thanks for the opportunity and time share to the all speaker. Big thanks also for Professor Dr. Khairuddin as a chairman of ADHKI, and especially thanks to the Dean of Faculty of Law, UPN Veteran Jakarta, Dr. Abdul Halim, and his staff, who are still enthusiastic to do something valuable during this pandemic. This is, I think, this is in line with our commitment that COVID-19 must not be barrier for us to remain productive. All academic activities must not be stopped. Of course, with maximum effort to stay COVID protocol. The objective of higher education, one of out of many is, I think, is to develop and share knowledge, technology and art, and also to optimize the society quality of the life and to preserve national culture. These objectives are implemented through research. This is the main idea, I think, behind INCOLS or International Conference on Law Studies, with which was initiated by Faculty of Law, UPN Veteran Jakarta. Therefore, I deeply appreciated all parties who participated in this event, the guest speaker, Dean of Faculty of Law Science, and the team who has done an excellent job to conducting an international webinar. I would like to also express my gratitude to all participants who have contributed to this event through their paper submission to share the insight of their research. The research topic carried out on family law, I think, is very relevant to current condition, especially in Indonesia. I think it is related to the impact caused by COVID-19. COVID-19 has triggered the emergence of various family cases, both diverse by economic or non-economic problem. The current pandemic is not an easy situation to deal with. The difficulties faced today must be addressed by strengthening each other, growing more solidly, and becoming more harmonious with facing various crises caused by the existence of COVID-19. The emergence of various legal cases in this pandemic era certainly has to be addressed critically by academic world. It is the duty of universities, especially law faculty, maybe to help solve the problem of basic needs of citizens by providing various alternative solution and anticipatory strategies so that community can avoid problems of violating the law. To conclude, my expectation for all the research that have been submitted is for it not only to be stopped here in this conference or other publication platform, but rather for it to be further continued so it can give an actual benefit to our society, as that is one of the main reasons why we all here in this event. I hope that all of you had a great time in this conference and gain a lot of original and innovative ideas as well. See you later in another occasion, inshallah. Assalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam warahmatullahi wabarakatuh. Thank you very much to Rector of Universitas Nasional Pembangunan Veteran Jakarta, Mrs. Dr. Hajatna Hernawati MACA. Ladies and gentlemen, the next agenda is praying by Mr. Dr. Haji Abdul Qadir Ibrani, SHI, MA.
Bismillahirrahmanirrahim. Astaghfirullahaladzim, astaghfirullahaladzim, astaghfirullahaladzim. Allahumma salli ala Sayyidina Muhammad wa ala Muhammad yuafi ni'ama yukafi mazidah. Ya Rabbana lakal hamdu kama yanbaghi ijalali wajhikal karim wa ta'ati sultanik. Bismillahirrahmanirrahim. Alhamdulillahil mahmud, as-samadil maqsud, dil karami wal jud, wal ata'il mamdud, wa fadlil masrud. Antal azizul baqi wal hafidul waqi. Lakal izzu wal baqa wal jud wal baha wal ardu was sama'u wa ma bainahuma wa ma tahta thara. Antal awal bila ibtida wal akhir bila intiha. Lakal asma'ul husna wal amtalul ula ilaika yafza'ul mahmud wa yarja'ul matrud tujiru man istajarak wa tafadhu man laja ilaik wa tughni man tawakkal alaik wa turshidu man ata'ak wa tu'izzu man a'tazza bika wa tu'minul khaif wa tansurul mazlum wa tu'til mahrum lakal hamdu katsiran bukratan wa asila. Allahumma inna asbahna ala withamika wa kunna ala babika nantadhiru bika rahmah wa ijabata da'wah harabna ilaka min sayyiati a'malina wa min kabairi dunubina wa laysa ma'ana ilaka wasila illa anta la malja'a wa la manja minka illa ilaika subhanaka Allahumma bihamdika astaghfiruka wa atubu ilaik. Allahumma sholli ala malaikatil muqarrabin wa anbiya'ikal mursalin wa khusus Muhammadan wa lahu bi afdali salati wa taslim wa barik alaihi wa ala alihi kama barakta ala Ibrahim wa ali Ibrahim wa du'ani syuhada'i wa sholihin innaka Hamidum Majid. Allahumma jama'ana hadha jama'an marhuma wa tafruqna min ba'dihi tafarruqan ma'suma la syakka wa la mafruqa. Allahumma fir lana wa li walidayna warhamhuma kama rabbayana shighara. Rabbana atina fid dunya hasanah wa fil akhirati hasanah wa qina adzabannar. Fa subhana rabbika rabbil izzati amma yasifun wa salamun alal mursalin walhamdulillahi rabbil alamin. Wassalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam warahmatullahi wabarakatuh. Thank you, Mr. Dr. Abdul Qadir Jailani, SHI. Honorable audience, the last agenda is the final agenda is closing. To close our program this morning, let's recite Hamdalah together. Alhamdulillahirabbil alamin. Finally, from the depths of my heart, I do apologize for all of audience. If you found many mistakes from my MC this event, thank you very much for your kind attention, and Wassalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam.
Mohon izin Prof. Bu Rektor foto bersama dulu dengan mengepal tangan semua apa? Tolong Pak Panitia. Jadi salam bela negara itu apa? Ya, mohon di apa? Ya, Prof. Khairuddin udah benar ini salam bela negaranya. Bu Umi apalagi ini. Mohon dipoto Rizky dan lain-lain.
Baik.
Semua lembaran.
Dalam pose bela negara saya hitung dari 1 sampai 3 ya. Yang pertama untuk slide 1 dulu. 1, 2, 3. Baik, untuk selanjutnya 1, 2, 3. Baik, cukup. Terima kasih.
Ya, Pak Kris juga salam bela negaranya bagus. Good greeting. Good morning Pak Kris.
Good morning. Assalamualaikum.
Mas Ardi mungkin moderatornya.
Buatun. Buatun.
Kita kan sekarang Ibu Atun yang sebagai moderator Pak Dekra.
Baik, terima kasih Ibu. Assalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam warahmatullahi wabarakatuh.
Rabbi shrah li sadri wa yassir li amri wahlul 'uqdatam min lisani yafqahu qawli. First of all, let's express our gratitude to Allah Subhanahu wa Ta'ala, who has given us the opportunity today to conduct our very prestigious conference, that is the second international conference on family law, contemporary issues on family law from various perspectives. Secondly, let's send our salawat to our Prophet Muhammad Sallallahu Alaihi Wasallam, who has taught us that seeking knowledge should be done by all people everywhere and anytime. Today, our topic is very interesting, that is about contemporary issues of family law from various perspectives. As we have all known that family law, like any other law, is facing dramatic changes in the last 20 years. June Starr, for example, an anthropologist, a prominent legal anthropologist, says that political changes and the conflict between state elites are the main factor for legal transformation in Turkey. Likewise, Benda Beckman found that due to the contestations between three different legal supporters, state official, religious clerics, and adat leader. Meanwhile, Arskal Salim, in his research about legal changes in Aceh, says that rapid legal changes cannot be well understood only by looking at a shift in social and political setting, but also we have to see some emerging and inevitable conditions, such as tsunami disaster, which plays an important role in promoting caning penalty in Aceh. Nowadays, we are all facing COVID-19, coronavirus disease 19, and this is one example of inevitable changes. So we are questioning what are the implications of those changes toward Islamic family law, and how can we situate new emerging topic for research along with these changes. And today we are having 5 incredible speakers from all over the world. The first one will be Ibu Dwi Arianti SHMH from UPN Veteran Jakarta. And the second will be Dr. Christopher Kaysan, BAGD from University of Washington School of Law, USA. From here, we are going to Leiden University with Steen Anhuis. And then we are coming back to Indonesia with Professor Hoirudin Nasution MA. He is also a chairman of Association of Islamic Family Law Lectures Indonesia. And the last will be Dr. Iwan Erar Yusef. This international conference is organized by the Association of Islamic Law Lecturers in Indonesia in collaboration with Faculty of Law, University of National Development, or Universitas Pembangunan Nasional Veteran Jakarta, Indonesia. Now, we will have 3 hours to have this first session. because I'm in Central Time, so it will be a bit different from the schedule. Now we are a bit behind of the time. We have 9:30 to 12:30. So all the speakers, we are going to give them each 20 minutes to present their paper. Without taking more time, I will please to Ibu Dwi Arianti SMH from UPN Veteran Jakarta to deliver her paper. The floor for yours, Ibu. Ibu Dwi Arianti, are you with us? Okay, Ibu Dwi. Yeah. You have 20 minutes to present your paper. Can everybody hear my voice?
Yeah, you can.
Okay, thank you. Please, Ibu Dwi Arianti. Okay, maybe it is still muted by the organizer because we cannot hear Ibu Dwi Arianti.
Halo? Halo?
Yeah, yeah. Now, yeah. Okay. You have 20 minutes, Ibu Dwi.
Oke, thank you, Ibu Atun Wardatun. Baik, sebelum saya mulai, saya mohon maaf yang sedalam-dalamnya atas kesalahan cetak pada flyer yang menyebutkan gelar doktor di depan nama saya. Mungkin pencetaknya merasa heran karena yang lainnya doktor, kok ada satu yang tidak doktor gitu ya. Jadi kami mohon maaf karena sebetulnya saya belum berhak untuk menyandang gelar doktor tersebut. Namun ini saya terima sebagai doa. Semoga Allah Subhanahu wa Ta'ala mengijabah doa-doa terbaik untuk saya pada hari Jumat yang penuh barokah ini. Insya Allah, amin.
Amin.
Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam warahmatullahi wabarakatuh.
The Honorable Professor Dr. Khairuddin Nasution as a Chairman of ADHKI, The Honorable Rector UPN Veteran Jakarta, Dr. Erna Hernawati AK JPMA CA, The Honorable Dean of Faculty of Law UPN Veteran Jakarta, Dr. Abdul Halim MAG, The Honorable all the speakers today, Dr. Christopher Kaysen, Mr. Tin Van Huys, and my colleague from UPN Veteran Jakarta, Dr. Iwan Era, Professor Arya Nakisa, and to all my colleagues, lecturer of Faculty of Law UPN Veteran Jakarta, and our colleagues from ADHKI, welcome to UPN Veteran Jakarta, and I appreciate to you all. Today, I would like to present a topic about the facts of furlough or layoff workers leading to increased force during pandemic COVID-19. This paper based on the idea that the policies for preventing and overcoming the spread of COVID-19 must be related by policies for overcoming and social problems. There are three reasons of increasing divorce during COVID-19. The first is a government policy about PSBB, regional social distancing on a large scale. The second is a decrease of industrial income. And the third, furlough or layoff the workers. Before I explain one by one about these reasons, let me show the data from World Health Organization about the number of COVID-19 cases in Indonesia until December, until today. More than 500,000 cases confirmed and 16,000 Indonesian people deaths because of COVID-19. This is a very large number of victims of pandemic in Indonesia, I think. The first reason is a government policy. Regional social distancing on large scale, or PSBB, based on Presidential Decree number 11 of 2020 concerning to the determination of public health emergencies from COVID-19, that the first COVID-19 as a disease that causes community health emergency. And Indonesia is mandatory to carry out countermeasures with the provisions of laws and regulations. This presidential decree valid from March 31st, 2020. Other government regulation is regulation of the Minister of Health Indonesia, number 9 of 2020 regarding scale of social restriction guidelines in accelerating the handling of COVID-19. In Article 2, PSBB territory has criteria. The first, the number of cases and or the number of deaths due to COVID-19 is increasing and spreading significantly and rapidly to several regions. And the second, there are epidemiological links with similar incidents other countries. The second factor is decrease of industrial income. Presidential Decree number 11 and the regulation of Minister of Health Republik Indonesia The existence of two rules issued a policy regional social distancing, the company to stop operating, and then the company going to losses, and the company losses enforces a policy to limit the workers, and they lay off the workers. Data of furlough or layoffs workers survey by Indonesia Central Bureau of Statistics for cnnindonesia.com on October 7, 2020. There are 5 company activities of percentage company activities to lay off the workers. We show that the reduced working hours 32 percentage, and then furlough or layoff without pay 70%, temporary layoff without pay 12, more than 12%, furlough or layoff with partial wage payment 6.4 percentage, and furlough layoff with wages paid in full 3.6 percentage. The highest percentage is reduced hours work and the layoff workers without pay in the second order. Reasons of company to furlough or lay off workers during COVID-19 by legalku.com is the first availability of industrial raw materials is running low. And then the rupiah exchange rate fell against the US dollars. Government policy prohibits traveling, causes tourism industry slumps, and the stock price index goes down, causes decreases. The facts of causes of divorce in Java Island increased due to COVID-19. The chief of the Supreme Court of Republik Indonesia said to newsdetik.com on August 2020, as a result of COVID-19, they said as a result of COVID-19, there were many layoffs so that the economy did not run better. This makes wife not guarantee from their husbands. I think these statements very related on facts that occur in our society now. The three facts about divorce on the island of Java. The first, the majority of plaintiffs for divorce are wives based on economic factors. The second, divorce lawsuits by wife are generally in West Java, Semarang, and Surabaya. Third, the government policy regarding regional social distancing, PSBB, in April until May 2019 closed during that time, so that in June until July 2020, the number of divorces increased to 57,000 cases. The factors that causes divorce during COVID-19 years 2019 until 2020, quarrels is the factor, is the most factor causes divorce, and then like economic problems, and then husband F5 died, and then this domestic violence, murtad, and polygamy. There are more than 6 factors that causes divorce during COVID-19, but in this presentation, limited to 6 factors during June 2019 until October 2020. Quarrel husband and wife is the highest number, and the topic is of quarrel is about decrease their economy. There are more than 6 factors that causes divorce during COVID-19, but in this presentation limited to 6 factors during June. And then quarrel husband and wife is the highest number of causes for divorce. The topic of quarrel is about decrease their economic, such as there is no money to buy household items, no money to buy some foods, no money for recreation like usual, and etc. This factor related to economic problems that causes divorce. And the conclusion are the COVID-19 pandemic led to the government policy to prevent and control the spread of coronavirus. Prevention and control is carried out by imposing policy of regional restriction, social distancing, PSBB, which causes all economic activities to stop. The stoppage of economic activities causes a decrease in industry turnover, which results in a reduction in the use of labor, so that employers impose a policy for layoff or layoff workers. Workers who are laid off without wages or partial wages cause economic problems in the family, resulting in quarrels that lead to divorce. Ladies and gentlemen, the conclusion of thank you very much for your attention. Wabillahi taufiq wal hidayah. Wassalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam warahmatullahi wabarakatuh. Thank you, Ibu Dwi Ariyanti Ramadhani. You use your time very wisely. Exactly 20 minutes. Okay, from Dwi Ariyanti's presentation, we can highlight the multi-dimensional of our family life, because as a matter of fact, she found that economic factors contribute to the increasing rate of divorce in Indonesia nowadays, also because of COVID-19. The primary factor is ongoing disputes, especially about economic issues in the family. Now, from Ibu Dwi Ariyanti, we are going to Pak Dr. Christopher Kaysen from University of Washington School of Law, USA, and he will also have 20 minutes to talk about international family law, especially about mixed marriage. Okay, the floor is yours, Pak Dr. Christopher Pak Dr. Chris.
Assalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam warahmatullahi wabarakatuh.
First of all, can everybody hear me?
Yes, we can hear you.
Hold on just a second.
Yes, you can hear you, Chris.
Sorry, I'm going to switch headphones.
Okay.
So, thank you to Ibu Erna, first of all, for hosting this event, and thank you to Pak Khairuddin again. This is my second presentation, so I guess the second annual presentation along with the first annual presentation. Unfortunately, we can't be in person this time. I will fondly remember our meeting in Bengkulu last year. And I wish, but I appreciate everybody for pushing through COVID and still organizing events like this. And I thank you to my moderator, Mbak Atun, and thank you for Dwi Arianti for clarifying some of the causes of the increase in divorce during COVID-19. I guess it's a bad joke, but I sometimes tell my students that if you're a divorce lawyer or a bankruptcy lawyer, you're doing very well during COVID-19, unfortunately, of course. Just a little bit of background on myself. I am from the University of Washington, but I am living and teaching at the moment in Yogyakarta, Indonesia. So I am familiar with some of the culture and some of the laws of Indonesia. In fact, I'm wearing batik today, sitting in my living room. And my approach to this is a comparative approach and a sort of an international law approach. So what my paper focused on was the Hukum Perdata International of mixed marriages and how they would be treated both in America and in Indonesia. And so we'll talk a little bit about private international law, but mostly I want to talk about what is the forum and what is the applicable law. So I want to give you a little factual scenario, and this is purely hypothetical. It's in no way related to anybody I know, but imagine that the wife in the marriage is a Muslim Indonesian and the husband is of a different religion and a different nationality. And the marriage happened outside of Indonesia legally, but was recorded inside of Indonesia. So all of what I'd like to talk about is sort of related to this type of factual scenario. And we'll make it even more complicated. We'll look at two children. One was a girl born outside of Indonesia, and one is a boy born inside of Indonesia. There's property, land and a house in America, but the couple's residence is in Indonesia, and about half and half of the property is spread between Indonesia and the United States. So I'm taking a little different approach. My paper is very boring and it's very technical, but so I wanted to sort of try to think of this in human terms. And those of you who have practiced and studied family law can sort of already see all the complications with this type of arrangement. And it highlights what I've highlighted in my paper, which is what we will call sort of this global marriage, where it's not purely a family law issue, but includes international law issues as well. So the first step is deciding where this divorce can take place. Okay, which court has jurisdiction over this marriage? And when I say Indonesian court, I'm obviously ruling out the Islamic court in Indonesia, because it's not a divorce sanctioned by Islam. And so that by itself complicates things, of course. And the American court may also have jurisdiction over the couple because the marriage the ceremony took place inside America. So we have what we call concurrent jurisdiction, which more than one forum has jurisdiction at the same time. And this creates our conflict of law. And so it's difficult to think about in this context, but which court will we use and which law will that apply? Now I should stop here, because if you do read my paper, it's also disappointing because there are no clear answers to these questions. Okay, to the point where it actually creates more questions than it answers. And fortunately, inshallah, this situation has not actually been a real situation, and I hope it will never be a real situation. So we don't have the body of law that has decided these issues, especially in Indonesia. So most of my research came from America because, of course, there are many cases that have dealt with this, but there are very few cases that have been published dealing with this in Indonesia. So that is applicable law. Even if, depending on which court this takes place in, we have to think about three things. One is child custody. Another is the grounds for dissolution. And the third is what we call the disposition of property. So regardless of where we deal with it, all three of these issues need to be addressed. So what I found in my research is that there are some common things and there are some. So one of the common things is that both American courts and Indonesian courts look at the law where the court was, where the marriage was originated. We call this lex celebration. And so even if the forum is in Indonesia, the couple would ask the court to apply foreign law. And again, this creates its own set of problems. An Indonesian court attempting to apply American common law in its court system Both American courts and Indonesian courts share this sort of hope that they can find this common, again, lex causi, applicable law. Another thing that I found was similar is that all courts look to, for child custody purposes, what is in the best interest of the children. And so that seems to be common. And then another commonality is that in dealing with disposition of property, is that it's based on location. So the property that's located in America or outside of it is treated the same way that would be treated inside that country. And property inside Indonesia, for example, would be treated the same way as it would be treated if it was Indonesian law. And then the biggest difference, however, and this goes back to our previous presentation of why people, about Wiaryanti's presentation, why are people getting divorced? And this is the biggest difference I found between the two applicable laws. So for example, in Indonesia, there must be a reason to get divorced. It's one party must go with witnesses to say this marriage, that one of the parties has caused the marriage to be dissolved. And this is very different from divorce in America and other locations where we have it what's called default divorce, which means that divorce can occur by agreement without any actual causes of that. So in my paper, I've shown that, again, it's very complicated. And the Hague Convention on Recognition of Marriage, that convention doesn't go far enough to address divorce. And so it's left up to the local courts, whether it's here in Indonesia or in America, to see these differences in the law. So again, my research questions were unanswered completely because these types of cases, as the title of our conference says, are emerging and haven't been settled yet, either in Indonesia or America or internationally. So my goal today was to have all of my colleagues here and the participants to think about what the implications of this type of marriage are, in that it's more of a thought experiment rather than giving concrete research findings. So I hope that it raises those issues, and I hope it sort of focuses your thinking beyond domestic issues and how international issues will shape marriage in Indonesia and beyond. So I'll leave my questions until later. I appreciate your patience And I look forward to your questions later on in the session. So, Assalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam warahmatullahi wabarakatuh. Thank you, Pak Chris. Think about family law only inside our day. We need to position this issue wider, covering international issues as well as gap in our literature. Okay, now from Pak Chris, we will come back to Indonesia. And now time is yours. Halo. Can you hear my voice? Can you hear my voice?
Can listen but unclearly. We can listen but unclearly.
Thank you for Pak Dr. Chris for bringing this issue to us. We all realize that we still have gap everywhere about international family law, especially in our research in Indonesia. But your international legislation, and also we know that Islamic family law is complex and complicated, so we need harder work to do research to uncover all infant will be the last presenter, and now we will give opportunity to Pak Professor Khairuddin Nasution, 20 minutes to present. Or maybe Pak Professor is not ready yet. Maybe we can please to present your paper. Oke, Pak Prof. Please, you have 20 minutes to present your paper. We are sorry because there is a bit different planning from the organizer, because Professor Steen van Huis will be the last.
Okay.
Okay, good.
Okay, thank you very much. Assalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam warahmatullahi wabarakatuh.
Assalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam.
I don't know, maybe there is a problem with the the content, not information below issue. Say issues. So when you want to write on Islamic law, or when you want to undertake research on family law, issues, right? Or when you want to publish subject family law, so it will be. So that's the subject I want to say. Right? Or when you so or Islamic family law studies, and also the object of Islamic studies, and maybe also legal grouping discussed about Islamic studies, and so legal grouping about Islamic studies in maybe so legal system grouping legal you want to say about Islamic studies. Something you can do. One is related to the Islamic concept on Islamic family law. And another word say, what is the Islamic renewal in Islamic family law? Because we believe the reform, the religion, or bring a renewal. So the question is, what is the renewal of Islam in Islamic family law? And some shows that the concept of Islamic family law is changing from what we call the racial, feudal law, and patriarchal law. It was in the Arab also Asia discuss, we have to socialize, we have to tell people that the Islamic law is based on the egalitarian law, egalitarian base. So that egalitarian and the fact have egalitarian base. It's the egalitarian husband, the egalitarian relationship between wife and husband. So then lecturers, and so then job, so then as lecturers in Islamic law, so then in Islam, we have to write in the light of the Islam. So then response. We have in the light of the Islam. So then our tip study comparative between the concept of Islamic family law compared to the Jahiliyah law or the Arab pra-Islam law. So by using this comparative study, hopefully will simply, and the people will understand that actually the Islamic law is to be equal to compare with the Islamic law has right of or the right to life between men. Compare between Islamic law and Arab Islam concept or Arab Islam legal law. We compare between, for example, in marriage, in divorce, in right and obligation of wife and husband. So by this comparison, we hope that we can compare and we know the renewal of Islam in Islamic law. So for example, we can say the life or the right to life between men and women is in Jahili. We just know that actually women for them is not a good infestation. So for Arab pra-Islam, men is the good infestation, women is not. So this way, when there was the baby, when they have baby, when it is that the woman, and then it's problem with that. And Al-Quran say, by saying that, impact or to say that it's not allow you to kill the woman. Women and men has the right, the same right, equal right to live. So we see the comparison. Pra-Islam put women in inferior status, men in superior status, and Islam come to put them in equal status, in equal right. So the right to live between men and women is the same, is equal. So it's different from the Arab pra-Islam. So by doing this, and then we write, and by write, and then we hope to publish, and by publish, then we hope that by this people change the idea, and after that hopefully change the behavior. And also the same case when we discuss, for example, the divorce or polygamy before Islam or Arab pra-Islam, divorce under the right. Maybe we say that the absolute right of the man, the absolute right of the husband. The wife has no right at all in divorce. The wife only passive in divorce. So the husband has this the right fully on the hand of the man, while women no right at all. And then this concept they changed by Islam by giving the who look to the man. The wife and husband fully has on the right to divorce. Islam only give to do initiate. So husband he initiate to divorce, wife also has initiate to do divorce. So the decision has to be in the court. The decision has to be in the third parties. Belong to the husband, not belong to the wife. But they have only right to initiate the divorce. So we can see the difference. So before Islam, the right is 100 fully under the husband, under the man, while wife has no right at all, and then is changed by Islam. Husband and wife has equal right. So this we call the changing, so the renewal of Islam. And that's all to analysis. The right of husband, the right of wife, we can see, we can compare. So this one aspect that we can see. So when we try to write, when we try to write issues in Islamic marine law, issues, when you say issues, when you say topic, when you say subject, so we can comparative study between Islam and Arab pra-Islam. And then the second one, there is a movement in the 20th centuries started by the Turkey, and this movement actually started. Okay, see this the comparative study, the comparative study, and then the second one there was in 20th century. Actually, the mission and the thing the good society. They see the behavior of the wife, the behavior of the husband, the life of the society is back to the pra-Islamic, let's say, is inferior. I said, not actually. On the mission of this law is actually try to put the the wrong behavior of Muslim society to be based on the Islamic norm, to based on the Islamic law. So then we try to see when we look at the society as it happened in Arab pro-Islam, the husband seems to have the absolute right of divorce. They divorce their wife sometimes without reason. And after divorce, they have no responsibility at all to the children, to the wife. Of course, it's not based on Islamic tradition. It's not based on the Islamic norm. It's not based on Islamic law. When the husband divorces his wife, has to be responsible to the child. But in fact, it's not. And then also the husband seems to have the ultimate, the absolute right to do polygamy without considering the competent. The all thing related to the polygamy, she just have more than one wife, but not responsibility. No responsible for the children, no responsible for the wife. So then, based on which we say that when we look at the Islam, people who do polygamy has to be responsible for all his wife and all his children. But in fact, it's not. So then, how can the practice of the family, the behavior of family back to the Islamic as it is bring or brought by the Prophet Muhammad SAW, in which you say before that based on equal right, based on equal justice, based on equal partnership. So then when we want to undertake research, when we want to write paper, we want to promote things, so this also thing that we can promote. This is all the thing you can write. So just write that what we write in codification in law number 1, 1974 is actually based on, and it's actually Islamic one. So when the society say that law of state is only related to the state business, it's not related to the theology, it's not related to belief, it's not related to religion. So our duty is to believe people, to say to them actually what we call fiqh, what we call fatwa, what we call jurisprudency, similar with what we call codification, what we call undang-undang, what we call other things related to codification in Israel. So by this, and hopefully the understanding of society will change. They say that, so by understanding this, by changing the understanding, hopefully also will continue to change behavior. So our job, our responsibility as lecturers in Islamic law, we have to write more, I say that as many as possible, promoting the concept of equal right in the life of society, equal right between husband and wife in family, equal right between men and women. So when we write more, hopefully, as we said before, when you look at the construction theory, to reconstruct our society from the superior-inferior relationship to be equal relationship, we have to write more, we have to speak more, we have to publish more, by which hopefully the change will faster. So we say that the more we write, the more we publish, the more we speak, hopefully the more the faster the change will be. So I think that's the mission of our conference. By this conference, we hope as many as possible to write the concept of equal right and equal relationship in family, equal right in husband and wife. So by which then hopefully more people read, more people understand, and hopefully then the faster will change. So the behavior of the society, the behavior of wife, the behavior of husband will be two equal right, equal relationship, equal benefit, and such and such. So that's I think the subject. So the second subject we can do is comparative study between Arab pra-Islam and Islam, by which you understand what is actually the concept of Islam in family. What is the renewal of Islam in Islamic family? And the second one, discuss or write or publish about the mission of the reform in the 20th century. The point of the reform, the objective of the reform is actually also to return back to the Islamic norm, because what we do in society now, what happening in society is not based on, because what's happening, the relationship between wife and husband is superior, inferior, not equal in a relationship, not equal partnership, not equal in other things. So the mission of this, how to back to the Islamic norm, where in the relationship with what is equality. So I think that's the second subject. So the second subject is related to the mission of the reform in 20th century. So we can write the concept, we can write the method, we can write the ultimate goal, we can write the objective, we can write the historical background, by which hopefully people understand what is the main point of this whole, what is the main point of the law. So also we hope that we can tell people that really the law produced by the state, like Undang-Undang Nomor 74, is similar with fatwa, it's similar with tafsir, it's similar with jurisprudency, in which based on Al-Quran Hadith and the quality even actually Undang-Undang more than fatwa, because Undang-Undang is the agreement of many people, many seculars, while fatwa is only individual opinion. So the second subject to write, the second subject we need to write, the second subject we need to take on this to undertake the set is the issue of the renewal or the issue of reform in the 20th century. And the third one, I think, try to do, especially in Indonesian law, is that we try to write to explain or to understand people, to believe people that actually the Undang-Undang Nomor 174, the KHI, and other laws related to family is more authoritative because, for example, based on the Abdul opinion, that actually this one is a kind of ijma in contemporary era. So in the era of the Tabi'in, in the era of the Sahaba, in the era of the Tabi'in, they have their own ijma, they have their own concept of ijma. But for ijma in this era is actually undang-undang. I mean the agreement of the let's say executive and legislative, or we say that the parliament, and this one is because this agreement of the seculars, agreement of the leaders. So this one is actually a kind of seculars and leaders actually, and at the time of ulil amr. So by saying ati Allah wa ati Rasul wa ulil amr minkum. So the meaning of ulil amr actually one of which is an agreement of the leaders and the secular. So when the leaders and seculars agree things, then for the Abdu is a kind of ijma for the temporary era. So then when we say that Undang-Undang 174, KHI and others actually is ijma of the seculars, if ijma in this era. So then this when we compare to fikih, compare to fatwa, to compare to jurisprudence, is more individual. So individual, of course, less authoritative. While in the ijma, when community, some of people or a lot of people, then of course we have we see that we put that is more authoritative than individual opinion. So I think these three things we have to think about, we have to write, we have to undertake, we have to publish, and so that people more reading, people more understand, and of course also we speech. So I think this is the point of this seminar, this conference. Our conference to speech, and then the result of this conference we publish. So by speed, some people listen to us, maybe they listen only, maybe they think about, maybe they consider to change, and then we publish, more people read, hopefully also the same thing, maybe some of them only read, maybe some other think to think, some others try to think about and take it into consideration to change. So by more we write, more we publish, more we submit, as you say, that the faster will change happen. I think that's all for my presentation, and thank you very much, and Assalamualaikum warahmatullahi wabarakatuh.
Thanks a lot to Pak Professor Khairuddin Nasution. I'm sorry I cannot turn my video on because to help the voice more clear to you all. And Pak Professor Khairuddin Nasution has given us ideas to enrich our research topic, because family law should be always adjusted with the dynamic changes of our society. Within the discussion, it should be considered human rights and gender equality perspective to ensure that Islamic family law can function as social control as well as social engineering. To quote Ziba Mir Hosseini, for example, in the past we have classical fiqh, and nowadays we have neo fiqh, and for the future we need feminist fiqh. Okay, now let's go to Pak Dr. Iwan Erar Yusuf. He will discuss about adat land and how the contestation between state policies with adat law regarding our adat land in Indonesia. Please, Pak Dr. Iwan, time for yours, also 20 minutes. Sorry, Pak Iwan, we cannot hear from you. Maybe it is still muted. Pak Dr. Iwan, we cannot hear from you. Please check the volume and also the sound.
Pak Iwan, kita belum dengar Pak Iwan.
Yeah.
Pak Halim bisa dijawab Pak Iwan.
Yeah, maybe the organizer can help Pak Iwan to check the mute
Pak
button.
Halim. Tolong Pak Halim dijawab.
Ya, we do.
Okay. Yeah, it seems that Pak Dr. Iwan still having technical difficulties about the voice. We cannot, because we cannot hear from him.
Telepon berarti itu tuh.
Or maybe because of the headset.
Mungkin.
Yeah, sometimes the headset is a problem.
Mikrofon.
Kedengaran di Pak Iwan. Nggak usah
Okay.
pakai headset, Pak.
Now it's okay. I can hear
Okay.
from you. Thank you. So 20 minutes for you, Pak Dr. Iwan.
Do you hear me, moderator?
Yeah, yeah.
Ya, kedengaran,
Okay,
kedengaran.
We can
Okay, yeah. Thank you very much. I'm
Clear.
sorry.
Okay.
Okay. At first, honorable to our chairman of association, Prof. Khairuddin, our rector, Dr. Erna, Dean, Dr. Halim, and the speakers and all participants. Let me to share my screen. Okay, I would like elaborate the data, especially to how to utilization of the adat land. Yeah. My topic is why I choose this topic is in order to increase the adat community prosperity. So the problem is how the concept in this discussion. Let me back to the historical and the political point of view of the adat law. Yeah, since the colonial period, there's a rising the three system in the colonial period. We call it the law, Islam law, and adat law. And the independence period, government, Indonesian states acknowledge the adat law, and in the rules of the agrarian basic rule in education, just say that adat law is still acknowledged as long as they're still alive and not gets to the Indonesian law. This is the problem. And also the Omnibus Law 2020 still, adat law is still correctly recognized by the government since as long as they are still exist. So in this is customary law, consists of customary law community, or we will call adat communities, and the customary land. Customary land have the characteristic, the concept is religious, communal, published, and cash and real. And the customary law based on the gynecology, what we call is patrilineal, matrilineal, neutral, based on territorial and combination of gynecology and territorial. This is the structure of the adat community. See, there's four composition: legal communities in the community and special form, the community and the environment of the king, the traders, and the composition of the governor during the Dutch colonial. So adat law is under legal protection for in our law stipulated in the Article 3 of agrarian rules, as long as the reality is still exists and not against the. Sorry, I'm sorry. So I would like to say that the theory from the prominent adat law from Dutch Van Vollenhoven says that the six characteristic of the adat lands, the something that one that has the legal leaders and the citizen, and some of customary law, and the last of the important thing that the land must not be sold to another party forever. This is the Van Vollenhoven theory according to the Indonesian land, adat land. I'm sorry to. And also the theoretically adat lands have the six characteristics, character of a relation in intra-communal and extra-communal relations. Also has the customary head communities, the function, dimension of the region, and restrictive limitation. And from this figure, we can see that how to utilize the adat land by the community and the outsider. So if the community of indigenous people utilize the adat land, they also only give the information to the leader. But if the outsider want to utilize the adat lands, they should give the permit from the adat leader and give the payment to the adat and has to comply with national law. These figures state that customary law communities as the pseudo government, which we compare with the modern states. And then what I would like to figure what the Indonesian positive law under the adat land. Considering adat land, we refer to the Constitution, Article 36, that the natural resource controlled by states for the greatest prosperity of the peoples. And then, according to the UPA, the basic rules of agrarian said that land or earth, water is belong to Indonesian nation, and according to based on the Constitution, give the authority to the states to control, and we call it hak menguasai negara. And from this situation, state give the rights to and distribute the rights to the people of Indonesia by regulation. Now we can figure that the national land law consists of the Indonesian nation rights. Second, right to control by the state or hak menguasai negara, customary lands, and individual lands. So I would like to figure the figure from the regulation that what we call the free state land consists of adat land and national land. And national land rights is individual, divided into the registered land, individual, and unregistered land. Registered land, what we call is tanah girik, yeah. And then also the other is management by state, what we call is hak pengelolaan and free state land. Yeah. This is the figuring of the Indonesian lands law in Indonesia. So according to the concept, agrarian is influenced by based on adat law, and also the Western law concept and others, something like the Islamic text. We can say that nowadays Islamic Sharia also influence to the land, and but before the adopted to the law in Indonesia should be centering or should be sorted by our Pancasila and Constitution. And then how the concept is implemented in the business business situation is rising the problem, legal problem. Yeah, there's an adat law, and the others is Western law, and other like the Islamic law. I think the legal problem what is say that transfer right of land. Yeah, the problem land, mortgage land, apartment law, other land registration. Yeah, since registration is based on the individual, but adat land is communal, and also the problem in concession awards on the adat land. And now, how about the implementation of the utilization of adat land regarding to Indonesian development? I'd like to give this samples about the how the government issue the policy, yeah, in releasing the land, adat land to outsider by government regulation number 5/99. So this regulation is this policy give impact the legal problem to the common customary law community. So the legal problem is the even if the releasing of the adat land considered to the customary law procedures, but the short regulation has led the many legal issue. And from my research, this is the problem is a sociological and philosophical point of view. Even if legally is already give the regulation, but not refer to the sociology and philosophy point of view. This is some example that the problem of how the policy to release the adat land issue the problem reclaiming of customary land. Such regulation has the impact to conflict between the community and the companies, even if something like the multinational companies. So this regulation is no mechanism control over unbalanced contracts, and also the condition ownership of the is not balanced between community and the multinational company. What we call this asymmetric information, such as how the indigenous people do not know the land have many natural resource, then they sell the land to the company with the low prices. Besides, the company, multi-company have the information, something like the GSM, well done, well know that the land is many resource of the adat land. So this is we call it asymmetric information. So the transaction is not equal. So how to give the explanation from the legal explanation? I would like to give the explanation from the government policy, the conflict, and the constitutional decision. Government policy says that the right of control by state is derivative from the constitutional that state should be give the prosperity of the people. But in fact, the nationalization natural resource with all the implications, including denying and negating the customary law community rights of the natural resource. This means that the implementation of right control state or hak nasional should not limit to existence of customary lands, because the relationship between the state and customary land community is an equal relationship. And then the originally Indonesian, the land is belonging to Indonesian people, and according to Van Vollen theory, stated that in basic rights, that she says the legal authority of highest law regarding the land in Dutch civil law and constitutional law, which cover the entire SRC plug Indonesia. In his theory, that Van Vollen gives 6 characteristics of Indonesian land law and agrarian law, one of which that the land belonging to the customary land community should not be sold off to another party forever. This is the theory from Van Vollen, the prominent legal expert from Dutch colonial. And then the conflict of customary law already give this some decision from the constitutional courts, and something like they have already some definition. What we call is the adat land is defined as this existence of the committee of the member and the existing customary assets already exists set of customary law norm already, and also the part of the customary law community units that are territorial, that there are also elements that of the existence of certain territories. This is decision of Constitutional Court giving the definition of the adat land. And also the Constitutional Court decision number 35 says that the existence of customary law forest is no longer included as a part of state forest. This means that on the customary land, there is a customary law community and a customary head who is a legal subject who is authorized in public law and civil law. And this decision is confessed that state acknowledge the forest, adat forest lands in the situation of this conflict. So my conclusion is how to increase the adat community prosperity. First, the Indonesian positive law stated that the entire territory of Indonesia is the homeland of all Indonesian people, and their relationship is eternal. This is in line with the Van Vollenhoven Basic theory, which states that customary land law is the highest law and cannot be traded or transferred to other parties forever. The government is not in a position to have natural resource, but is present for formulate policy, make arrangement, conduct management, and conduct supervision. The government must pay attention to the existing rights, both individual rights and collective rights, customary rights and other constitutional rights owned by the community and guaranteed by the institution. The state should recognize the existence of the rights of the community, including customary land, as long as in reality there must still be reinterpreted that the state guarantees and preserve not only the guarantees but preserve the existence of the rights of the community, including the customary land and the greatest prosperity of the people. This is my presentation is from this we can say that we can increase adat community in the greatest prosperity of the people, including their family. Okay, thank you very much for this presentation. Thank you, moderator.
Okay, you're welcome, Pak Dr. Iwan. And it was a very good presentation. Thank you for putting in the table the topic about adat land because sorry, why this happening? Okay, yeah. Sorry, I will repeat. Thank you for bringing to the table, for putting to the table this topic about adat land because it is very interesting. And also, we know that the ownership of land also has something to do with family law. For example, some scholars has pointed out that the limited availability of land in Indonesia as an agrarian culture contribute to the increasing rate of school dropout, and parents tend to marry off their daughter in young age, under age married. And now we still have 385 participants for our conference. It's a very big international conference. And please, we still have 1.5 hour to go. And last but not least, we will have our last speaker from Leiden University, Professor Stijn van Hees will discuss about critical analysis on some topics in our current Islamic family law. This is similar to the topic that we have been discussing with Professor Khairuddin Nasution before. So Professor Stijn van Hees, time for you 20 minutes to do your presentation, please. Yeah, we are still waiting. Pak Stijn van Hees from Leiden University as our last speaker today. Pak Stijn, are you with us?
Halimnya nomor Pak Stijn.
Dia minta undur sedikit lagi.
Oh, okay.
Mungkin bisa diskusi dulu.
Ya, ya. While waiting for Pak Professor, we have around 1 hour 15 minutes to go. So maybe we will at this first question. We have almost 100 participants today. It's very big international conference. I also see one question from to for so maybe can this chat.
Ini yang kurang anu gitu jaringnya Atun atau mana ya?
Kayaknya dari Bu Atun kayaknya.
Kalau kita jelas ya?
Jelas, jelas.
Oh ya.
Is it clear?
Iya, kita saling kita agak clear, tapi Bu Atun itu agak hilang-hilang.
Sorry. Okay. Maybe this Christmas
atau sementara moderatornya diambil alih Pak Halim biar jelas.
Yeah, we can do that.
You can be moderator now because Bu Atun is quite a problem with this.
Jelas, lanjut saja, Bro. Nanti ada backup sama Rianda, nanti Rianda bisa.
Nah, ini kan ada waktu kosong, mungkin diskusi. Question and question partisipan.
Halo. Nggak tahu ini.
Okay, everybody, all participants, because there's problem with the Bu Atun, maybe the line is under the. So if there is any question, can please ask to all the speakers, Bu Dewi or Christopher or Pak Iwan. Please, you can use chat or maybe you can you raise your hand. Bu Atun, apa sudah ada yang bertanya?
Belum ada, Bapak.
Okay, participant, if any question from you, please. Just
I'm
stop.
sorry,
Just.
Mr. Khairuddin.
Okay,
I'll
okay,
take
please.
over
Please.
the agenda as the co-moderator. So if there's any question.
Okay, please, Anda.
Okay, thank you. Thank you, Professor Khairuddin. If there's any question for the narasumber, you can raise your hand so you can ask directly to the narasumber. If there's any question?
Hello, is it clear now?
Yeah. Quite.
Yeah.
Okay, that's fine. You can help me to be a moderator, and also we have a questions in the chat, so we can read this question for fighting.
Jogging gitu kan besum perut gede mulut kecil ngapa sih megang-megang sama apa?
Okay, there is a question from Haji Sukmawati from IAIN Palopo. Her question is for Professor Christopher. So for Miss Sukmawati, you want to ask directly or can I read the question? There is Miss Sukmawati. Okay, I think I read the question.
Please, Pak.
To Mr. Prof. Christopher, first, whether there is contemporary. So please, the other voice. Okay, thank you.
Thank
First,
you.
whether there is a contemporary inheritance issue in your country. Second, how to distribute inheritance to have children's parents and son. Thank you. So that's the question for Professor Christopher.
Okay,
you want to answer now or
sure?
Still waiting the other question.
I'll answer now, and then other people can
thank you.
post more questions. Yes, so thank you for the question. And first, just in American law, family law and inheritance law are sort of two separate areas. So just, experts in inheritance law are different than experts in family law. But one of the big differences is that in inheritance law, the estate can designate that person wants. So through a will, you can designate your issue, your children, other people. You can give 100% to one child and 0 to another child. There's complete freedom to designate many famous cases where the children will challenge the inheritance or will challenge the will, and the children will fight with each other. There's even a famous Charles Dickens novel from 300 years ago about people fighting over inheritance. But If the person dies without a will, and we call that intestate, then essentially it is divided. First of all, if the person's married, then all of the community property, the shared marital property, goes to the spouse if that person is married. Okay. And any separate property goes to the children. So it doesn't go directly to children if the person who dies is married. Again, it's really complicated. But if the person dies and is not married, then it's just equal among the children. So again, it goes back to family law. What we call community property plays a big part in inheritance as well. So again, how it's divided can be planned or unplanned, but I always recommend to everyone to have a will so that your intent to how your estate is distributed is clear. But it can be distributed in any way that the person wants. It's not dictated by any particular law. So again, it's much more complicated. I hope I answered your question. Please follow up if I did not. Thank you so much.
Thank you, Professor Christopher, for the answer. Is there any additional answer from Professor Khairuddin to answer the question?
Saya nggak punya pengetahuan tentang hukum Amerika. Paling
If you want
Korean
to
itu
share
ya,
your
Mister?
experience.
No, I don't have any experience.
Well, we waiting the other question.
Or maybe there is a follow-up questions from Ibu about this. It's very interesting to know inheritance law is different from family law in America, because here in Indonesia we put it in different books but under the compilation of Islamic laws. And also it seems that in America it is more important to have a will than to fight about inheritance. There is no inheritance rules because people can be free to give the property to anyone else or to one children 100%.
Oh yeah.
Yes,
Yeah.
there's even a famous story about a really rich woman. She was a billionaire and she left all of her money to her dog.
Oh, yeah.
Yes, it's true. It's a funny story, but it's true. She left $1 billion American dollars, and her dog had a whole house to itself and a whole staff to take care of the dog. So that's an extreme story, but it's one example of how even crazy people can have freedom to distribute their estate. Sorry to interrupt.
It's okay.
That's very interesting. That case you arranged.
It's a strange case, but a good example.
Sad but true.
Sad but true, yes.
So maybe some participants can also raise questions. You can do it through chat or giving directly questions to all speakers that we have today.
Or maybe when we discuss about the inheritance. Also in Indonesia, there is a chain from the, what you can say, now people tend to doing musyawarah by, what do you say that? is recognized by KHI. I mean that the way to distribute the inheritance not only one way, it can be many different ways. It can be by musyawarah among the people, the ahli waris. Can also be maybe like hibah given by the waris, and in some cases also, even though to the man, for example, 2 wives compared to the man, then the man give his right to this woman, though they say that his brother or his sister. So it means that there is many ways people do in the distribution of inheritance. So it's not only one way. Even though when you ask people, you say that, yeah, lidakari mithlu hadil untaya, lidakari mithlu hadil untaya. But in fact, it's not done. Meaning that people tend not using this way. So that is why I think, like Munawir said, that actually have to be consistent between what we're saying and what we do. Not saying that has to be 2 wives for the men, once for the women, but in fact you give equal right. So between say kabromatan indallah antakulum manat, only say and just do. So by which then we try to do, not only saying that lidakari, but we also say that yeah, there is possibilities or some other way to distribute inheritance. It depends on the agreement among the ahli waris. So maybe this concept we say that socialized to the society. So even though you distribute the inheritance not based on what you say the dakari, but in fact there is possibility in Al-Quran to do another way, to do musyawarah, to do agreement among the ahli waris. Maybe also I think another way to say it to the people, so that not only people think one way, the absolute way, but in fact there is any way to distribute. I think this additional that explanation with that. Thank you.
Yeah. Okay, we are still waiting for the questions. Or maybe Pak Dr. Chris can give us some more insight about no-fault divorce, because in Indonesia we have to have so many reasons to be able to have divorce, and we have increasing rate of divorce, even if it seems that our Islamic court problematize the divorce so far by giving us the difficulties in having divorce. What about in America? By having no-fault divorce, you don't need any reason. What about the rate of divorce compared to Indonesia or to any other place in the world?
Well, I don't know the exact rate, but the divorce rate in America is very high.
Mm-hmm.
So you know, it's very, very common. It's almost rare to find couples who have never been divorced or who have parents who have never been divorced. It's actually more common to have at least one divorce in your life. But again, there's less stigma to the divorce as well.
Okay.
So although, of course, it's not favored, and the different religious organizations, for example, the Catholic Church doesn't allow a divorced person to get married in the Catholic Church again. It's very common, and it's considered more of like a partnership dissolution, like a business transaction in that sense, that a divorce proceeding is not about fault or problems with the marriage. The judges do not examine why a marriage failed. They just focus on the property and, of course, the children, and looking out for the best interests of the children. And, you know, Korudin has pointed out today that we need equality in these domestic proceedings and these family law proceedings.
Yeah.
And, you know, in America, legally, there is equality. So if you look at the law, both parents are treated equally,
Yeah.
and male and female children are treated equally. But practically speaking, there's still, in general, the mother gets the children in custody.
Custody.
Yeah, so custody of the children. Who has the children? It's generally the mother, even though it's not a legal distinction, but it's a practical distinction. Yeah, so the equality is, it's technically that way in America, but not always in practice as well. And there are some religious implications. The United States is not a signatory to the United Nations Convention on the Rights of the Child, so it's outside that purview. But generally, the no-fault divorce has allowed, if people are unhappy, they can get divorced and just say, I'm unhappy, I don't want to be married anymore. And so, of course, I don't know the statistics, but I believe that has led to many divorces. If you just look at Hollywood, if you look at all the movie stars, you can see all the divorces. Okay.
Oh, okay, Chris. It's interesting, Chris. Means we Indonesia try to say that the reason for higher number of increase of divorce in Indonesia because they don't know each other. Because it's too short to understand each other. But in fact, in America, where couple have already understand each other more, even very long, but in fact, the number of divorce is still there. So how can we explain this like Indonesia?
Well, I think also, people get married for different reasons too.
Yeah.
So it's not so much about the family unit, it's about the individual. And so part of that individuality is people change and people are more selfish in America, I think. So they think about their own happiness rather than happiness of the whole unit. And so, a lot of people, everybody I know who's gotten divorced said, I was happy at the beginning, but things changed. And so usually a change of circumstances. Again, this is not scientific, but that's just my, anecdotal.
But it makes sense.
Yeah, and again, it's partly cultural, but it's somewhat legal, but mostly cultural.
Yeah.
Okay. Is there any news from Pak Stin?
It's really early in the morning there.
Okay, that's the problem. Okay, then we are still waiting for the questions from the participants. Yeah, while waiting for Pak Professor Stin. And Pak Professor Dr. Hoirudin, what do you think? Can we, in the future, can we have no-fault divorce in Indonesia? Because it seems that we have different direction from America's policy. Of course, talking about equality in marriage, we agree on this. We agree on this. But in Indonesia, rather than making a no-fault divorce, we're focusing on having family resilience, where people in the family should understand each other, should try to tie this knot very strong. And I don't know if we can think about no-fault divorce in the future. Maybe you have an opinion about this.
Yeah, so that's why I said before to the Chris that in fact, Indonesia always say that one reason for the divorce is because the husband and wife, well, let's say the partner, not understand each other. It's too short for them to understand each other. And that's why I say that, for example, in Indonesia, you say that because of the rule of the role of the wife, the wali, in some cases, because the partner, especially the women, there's no choice to have her partner or her husband, but it's under the father or maybe the grandfather or somebody else, and then it becomes a reason. Why? Because they don't know each other. But in fact, so people try to say when one each other is no, the family, the relationship will be, let's say, more strong or stronger than others. So because they prepare, they understand each other, say others, so in fact, then they will be different because they already know before. So then they will solve. But in fact, in America, when they have even I think long time to know each other before married, but in fact, the number of divorce is still higher, still there. So then this reason can be said maybe improve. For now, maybe not only because of that reason, but understanding the right, because I understand that's my right, and maybe also another explanation from the Chris, because people tend to think about maybe we say the individual happiness, happy for her, happy for him, without thinking about the happiness for all, say that the members of the family, for the children, for his partner, their husband and wife. So when it's not good for her, it's not good for him, then just go. So it means that we try to find why people tend to think that. Because when we are in family, when we are in group, when we are in organization, if we need the organization to be stay, to be remain, of course we have to understand each other, we have to respect each other. So if the family is not done, they just think about himself, just think about the interest of each, not the interest of all people, of the members of the family. Of course, it will trouble in the future. So I think we have to, what do you say, that we have to tell people actually when you are in group, when you are in organization, when you are in wherever, if it is with other people, we have to think about other people. We have to think about others. So in family, also you have to think about if you have your husband, your wife, of course you have to think about your wife, your husband. If you have children or child, you have to think about them. If you are only for you, of course it's not family. It's individual life. It's not family. So I think this thing we have to keep in mind and try to build in the society that actually in family need to be partnership, need to understand each other, need to work together, need to think about, consider taking to consideration the interest of others, of the partner, of the children, of all members in family. So I think that's another way to say, let's say to keep the family in happy life. Means that family happy life, or we say that the family happy or happy family, not individual happy, not husband happy, not wife happy, not child happy, but family. So the happiness of family has to understand each other, has to consider each other, has to think about the interest of each other. So I think that's the thing that we have to need to let's say to increase. Okay, thanks for Atun.
Yeah, it's very interesting. Maybe while waiting for the questions, also we can hear from Ibu Dwi Arianti, because Ibu Dwi Arianti has just discussed about the increasing rate of divorce because of COVID-19. What do you think, Ibu? Because in Indonesia, the rate of cerai gugat, divorce initiated by the wives, much more higher than the divorce initiated by the husband or cerai talak. Do you find the same thing during the COVID-19? Because as we can see from the data, 2019, almost 350,000 cerai gugat, compared to only 150,000 cerai talak happens all around Indonesia from Badilak data. Maybe we can go to Ibu Dwi Arianti. Do you find the same thing during COVID-19? Because you've mentioned about economic problem behind the increasing divorce rate. And Indonesia, we know the economic financial support usually is the responsibility of the husbands. Maybe we can hear from you, Ibu Dwi Arianti. Again, the participants, we are still waiting for your questions or your comments. It's okay. Yeah, Ibu Dwi, please. Ibu Dwi, are you still with us?
Pak Halim, bisa japri?
Ya, Bu.
Okay, yeah. We can hear you, Ibu Dwi.
Yes, I'm sorry. Actually, I have had a fever and headache since yesterday.
Suaranya sehalus orangnya ya?
Yeah.
Yes. No, I'm sorry.
Yeah.
Actually, I have had a fever and headache since yesterday, but I'm trying to be here.
Okay, yeah.
Yeah, I'm sorry. I'm not off camera because I'm terrible. You see.
That's fine, Ibu. It's fine, Ibu, as long as we can hear from you.
Okay. There are my data about the divorce during the COVID-19. I just put one recent data. The facts of divorce is caused by economic problem.
Yeah.
That's it's the fact is around this today. That's my opinion, Bu Atun. Thank you.
Okay, is there any stigma, Ibu, to the wife who initiate divorce in your finding, or maybe you don't touch this issue? Because in Indonesia, I know that if the wife initiate divorce, there will be so bad stigma to them,
Yes.
different from if the husband initiate the divorce.
It is so many reasons. Wives Indonesia maybe apa itu not budaya, usia perkawinan yang terlalu muda juga sehingga kedewasaan dalam menerima kenyataan-kenyataan masalah-masalah yang terjadi selama COVID itu juga bisa mempengaruhi. Saya lihat di sekitar saya tinggal di Depok ya Bu, di Pengadilan Agama Depok itu sampai keluar. Ini yang antri mendaftarkan gugat cerai itu almost women yang mendaftarkan gugatan cerai. Dan dari pembicaraan mereka terlihat memang masalah ekonomi yang paling banyak.
Okay. Yeah. So I think everywhere we have long line waiting for the decision in our Islamic court, and most of them are women in their young age. As the joke from Pak Chris,
Christoph.
Apa tadi jokesnya? Divorce lawyer earn a lot of money during the COVID-19. So advantages for some people, disadvantages for many people. It happens. Okay.
Saya am a lawyer.
Bagi sebagian, ketidakuntungan bagi sebagian lain.
Can I answer, please?
Yeah, Ibu Haliah, maybe do you have questions?
I will ask.
Yeah, please, Ibu Haliah.
Thank you very much. I will ask something to Mr. about last time he sentenced the choice of law in international marriage, divorce, especially about the child custody.
Child custody. Okay.
I will ask about, is there influence to age? For example, the children under 8 years old or over 18 years old. because last time a couple from Indonesia, wife, Muslim and husband American Catholic. So I think there is influence to children, and they have one children. So is there influence to age? For example, the children under 18 years old or of 18 years old.
Yeah. The question is for Dr. Chris, right? Ibu Halia.
Okay.
Okay.
Well, first of all, if they're over 18, if they're adults,
Yeah. 18?
if they're over 18, we don't care, right? They're not subject to a custody agreement.
Yeah, yeah.
There are some financial issues in America between 18 and 23, but over 18, there's no issue. But you're right in that depending on the age of the child, there is a difference. So for example, as the children are younger, there's definitely a preference towards the mother being the caregiver. And again, it's not a legal preference, it's just a cultural and sort of a common law stare decisis preference to that. As they get older, the concerns are more financial. Who is in a better financial situation to care for the children? And you know, again, it's not equal. And when it comes to custody of the children, we go back to, even though it's a no-fault divorce, when it comes to custody of the children, even though the divorce can go through, we base custody on the character of the prospective parents and their history and things that would be, you know, in Indonesia would be grounds for divorce, are grounds for custody in American proceedings. So it does come into play. So even though it's no fault divorce, the character and the actions of the individuals morally come into play in custody of the children.
Yeah, yeah.
So thank you for your question.
Yeah. Okay, Ibu Hilia. I think it's very clear from Pak Chris about the age, because maybe we have also different culture here in Indonesia. Even if you are 80, not 18, you are 80, you still expect help from your extended family, including your mother and father. I myself still get rice every month. They send me rice. If I'm forced.
Alhamdulillah.
Beras. Kilogram every month. I don't know why.
Just send it to Jogja.
They still send me. But in America, for example, yeah, also I think it happens in Australia, in Western country. If you are 18, usually move out from the house, and then of course in this age, child custody is not a subject of discussion anymore. Oh, okay, good. Thanks, Pak Dr. Chris. Again, we are still waiting for the questions.
What time Pak Stins will come?
Yeah. Now maybe a question for Dr. Iwan. Yeah. Pak Dr. Iwan, are you still with us? Yeah.
Yeah.
As I highlighted before, I'm trying, because I don't know exactly about the adat regulations or state policies about adat land. Maybe I'm trying to connect our discussion to family law. What do you think? Because scholars of Islamic family law also say that the ownership of land contribute to the increasing rate of early marriage in Indonesia, because the limit of land availability makes people having problem with the economy, and then the your parents tend to marry off their daughter in early age. What do you think about this? Maybe you find some facts about the connection between ownership of land to the problems in Islamic family law. Yes, time for you, Pak Dr. Iwan.
Yeah, I think this how to utilizing the adat land in according to Indonesian law is still many problems, since the concept that the adat land is cannot be registered in the systems.
Okay.
But some province by the regulation, local regulations could be registered. It means that the adat land is two kind of adat land, communal and individual. Individual land is not this. It's not mean the privately, but private by the public procedure is not originally privately. It means that how the family has the individual lands from the adat land community is still many face the problem how to sell to their family, since they have to sell to the other community people first, or to the other leader first to get the permission. So the how to family to use the adat land is very and still many problems, since they cannot be registered and cannot be give the collateral in case that they have to get the money from the lands. This is a problem. The problem is the concept of the adat law is different with the Indonesian concepts. What we call is registration is individual concept, and this influence to the family prosperity, including the how to get the married by sell their individual lands. This is the problem.
Okay. Yeah. So
Or
in
maybe
yeah, Pak, please, Pak Prof.
no, just maybe if it's the discuss about the adat land, but to say that individual land,
because in the society it's not, maybe commonly it's not registered.
Yeah.
Then in some cases somebody comes, maybe in cooperation with the PPT or the Camat and others, and then individual land is registered under the name of this businessman or somebody else. And then after that, the individual who think that it belong to somebody, and he claimed that this belong to him. And also people know that this belong to him because they know it's from maybe his father or grandfather. But the question is, the problem is not register. And then somebody else come and he register, and the Camat, the PCR say that the pencatat tanah, you give the what do you say that the proof of the, and in fact, then the end after this somebody have this proof, and then he claimed this belong to him, and it may happen many times. And actually, and in fact, if that this bodies, this businessman is the winner in the court, even though society, even though community know this actually belong to this person, belong to this the common people, but only because the problem is the proof no register. So how let's say that the common people to what do you say that to prove that this belong to him, and in fact this body is already the akta tanah, and this common people has no akta tanah. So how what's the solution? What is the solution for this problem, Pak Iwan?
Yeah, the problem is individual land means is that this is a public dimension. It means that individual land, if they want to sell to them, the problem should get the permits from the leader or the other families. And Indonesian system is not accommodate this communal system, but some province like Sumatera Barat, West Sumatra, they can register by the procedure that the government or the people or the society initiate to get the province regulation or local regulation in order to get the central government to provide the regulation of registration. But this not on all the province doing this matter. So the solution is it means that all province should get the local regulation in order to registration, because the system is not accommodate, but it's a faculty, facultative. Facultative means it could be registered. So it means that need the initiative of the society to register the adult lands, and this is should be socialized to another province in Indonesia in order to protect the family of adat law, in order to get the how to do utilizing the land, something like for their family and the prosperity of the family, something like how to need the money from their lands. It's something like this. Already.
So not many regional government doing this, only West Sumatra, but others no. It means that majority of the government in districts still not think about this. Only West Java, so only one from how many provinces in Indonesia. So it means that West Sumatra may be smart government or smart district government, but the others don't take into consideration, not take attention for this problem.
Yeah, I think it's depend on the district government, the initiative from the government, how to initiate to take the central government to register the adat lands.
Okay, thanks Bu Atun. Oh, Bu Atun sudah hilang. Gimana Pak Stefan Kus, Pak Alif? Any comment from somebody else?
Okay, excuse me, Prof. Bidin. I want to give some announcement to the participant or the audience. Everyone can fill the link on the chat to get the e-certificate and to fill the list of attendance. Thank you. And there is a question from Mr. Wazni Azwar. Is there Mr. Wazni Azwar?
Yeah, you can read, Pak.
I will read the question if Mr. Wazni Azwar. What is meaning of family for Indonesian Muslim and for America? And the second question is, the equality is regulated by government. In fact, the societies have different view in practice. Some of them make negative prejudice to government. It looks that the meaning of equality has been interpreted differently by person, society, and state. Number 3, in addition, some people say that happiness is goal of life. So, equality and happiness, how to make them support each other, especially in this COVID era, toward harmonization of family? Thank you. Oh, Mr. Wazni Azwar have problem with his microphone. So, Mr. Professor Christopher, you can answer the question, or Professor Khairuddin. Thank you.
Dwi Aryani.
Yeah, I think all the speakers can answer the first question. What is the meaning of family?
Who should go first?
Chris, yes, Chris.
Yeah, Pak Chris first.
You are the first.
Well, okay, so I'm a lawyer, not a philosopher. So my answer is not very romantic, but you know, sort of the American view of family is it's a legal relationship. So when two people get married, it changes their legal relationship, like a contract or anything else. And so under the law, we only care about that legal relationship. We don't ask why people want to get married. We don't ask, we don't, so the idea of family is just, you know, under the law, it's just a legal relationships between husband and wife, between mother and child, between, you know, so under the law, we see family, again, very unromantic, as just what is the legal relationship? And so I think as a society, we encourage families. Even we encourage family over individuals. You know, we recognize for tax purposes, we recognize families as different. But legally, we don't prefer families. So, you know, what family is sort of whatever we make it. And I'm going to say this, I didn't mean to bring it up, but we also have, you know, same-sex marriage in America now. So what a traditional family, a husband and a wife and children, is very different now. But again, because it goes back to those legal relationships, it doesn't matter. But we also hopefully give freedom to different religions to regulate how they, you know, for example, I'm going to use the Catholic Church. So even though the whole country, two men, we have gay marriage, it's still not allowed within the Catholic Church. So to have your marriage recognized religiously is still free to the religions. So we can't force the Catholic Church to accept a gay marriage, or we can't force Muslims to allow non-Muslim marriage. We can't do that. So, but again, on a legal basis, it doesn't matter, but we still allow for the traditional family and still allow for for religious marriage to regulate itself. I don't know if that answered the question or not, but that's sort of what the unromantic viewpoint of a lawyer is. Thank you.
Yeah. Okay, thank you, Dr. Chris. Yeah, of course, the definition of anything, it should be based on the, you know, like individual perspective, their experience and everything. So because you are a lawyer, of course, it's very legal definition. Okay, Pak Dr. Khairuddin, do you want to say something about this? or we are going to second question?
Yeah, maybe family can share relationship. Sorry. Maybe we share relationship between men and women to become a husband and wife, build and commit to be one life. It's called family. Or a commitment between men and women to be one life, which is called family. So then family is the two people to agree, to commit to be one life. And maybe, yeah, when you say when related to the Islamic teaching, based on the, what do you say that? Based on the Islamic norm or based on the religious teaching. So meaning that the relationship is they build the relationship because the religion asked them to do. So it's not merely individual relationship, but maybe also inside there is also, when you say that the spiritual or you say the theological aspect. So that's why in family is not only individual relationship, but also we say that what we call like ibadah. So a kind of ibadah, even though we say anything you do, of course, it's called ibadah. But in this case, to be maybe special, that your relationship in your family is not the same with your business, meaning that when you have a business with somebody else, this one is maybe merely individual, but for this case, it's not individual, but yeah, individually based on the spiritual aspect, based on the Islamic norm aspect. So it's not individual relationship, it's not merely individual commitment, but religious commitment to build or to become one is called family.
Okay.
I don't know.
Oh, yeah. This is more romantic, Pak Dokter. Because more than legal contract, but also spiritual.
Yeah, more than legal contract, yeah. More than individual.
So what do you think about the meaning of equality? Because it says here that different person, society, and state gives different meaning toward the term equality. Do you think
So that's
does
why
it sound right?
to explain before, when you are in one group of people, even only between you and somebody else, if you work together, if you are as a partner, if he or she will be your, so when you have equal relationship, hopefully you will be succeeded, meaning that when we say we have objective, what you want or what is your objective will be easier for you to achieve than when you do it like not equality, because you are superior or the other superior. So based on this equality, hopefully so that equal relationship, equal right and wife, equal is not mean the same. Equal is equal. So maybe you have like an agreement. For example, when you think that this job better if is done by your partner, and then okay, and another job, for example, is better by you, and then okay. So it's not to say that equality is the same. No, equality is not the same. So then equal relationship, equal right, equal justice means, yeah, you have to think other people as you, and you have to think you as others. So when you feel it's not good for you, you don't do it with others. So if you think that it will not good for others, so you don't do it for you. So this is the equality. So you have to feel other people is as you. You have to think your partner is as you. So by which then we try to work together, we try to understand each other. So I think that's the meaning of equality.
Okay, thank you, Pak Doctor. Treat other people as you want to be treated, is the quote of the day. But now we have Professor Steen with us. Welcome, Professor Steen. Because we still have 20 minutes to go, so I will give just all the time for you.
I'm so sorry that I'm late today.
And thank you for being with us now.
Can you hear me?
Yes,
well?
yes.
Yes, we hear you.
It's clear.
Okay. Okay, let me introduce myself. I'm not yet a professor. I'm a doctor, Dr. Stijn Cornelis van Huis. I'm an alumni of Leiden University. I wrote my dissertation on religious courts, pengadilan agama in Indonesia, and I did field research in Cianjur and Bulukumba for this promotion, for my dissertation PhD research, and especially about the religious courts and divorce and their role in upholding divorce rights in Indonesia, but based on my studies in Cianjur and Bulukumba. Today I will present, I hope I can share screen.
Yeah, you can share the screen. Okay.
Yeah,
Okay,
sure.
yes, it's visible, right? I will. It's not yet full screen. Yes, now it's full screen. It's about changes in Indonesian Islamic family law. This is partly based on my research, my PhD research, but also I've done some, 2 times I've done a postdoc in Germany, so at Max Planck Institute for Comparative and International Private Law. I've done research about khususnya about children's rights in marriage. Am I still?
Yeah.
Can you hear me clearly?
Yeah,
Or
yeah,
is
yeah,
there-
yeah, yeah.
Hear you
Clear.
very clearly.
I think my headphone has a problem then, because I hear some noise. Yeah. I will try to do it without. Can you hear me now?
Yeah, yeah.
Yeah.
Yeah, we still can hear you.
Okay. Then I will just ignore the problem in my earphone. So I have the following outline. Introduction, but I already introduced myself, so I will skip that. And then some topical issues. So one is about isbat nikah, where I found that the Mahkamah Agung has broadened the scope of isbat nikah to include registration of marriage in the best interest of the child. So for the purpose of the registration of the child. A perceraian, so divorce, non-fault divorce, nafkah anak, the problems with enforcement, executie, nafkah idah, muta kiswah, and cerai gugat cases. Also the same problem with executie, but there are also some other issues I want to discuss. And then joint custody and parenting plan as a new phenomena which maybe will develop at the Islamic court, and some issues about with adoption or anak angkat. It's a lot, but I will just describe some of the developments that I found that are happening now. The perceraian is, so divorce is not so new, but one of the things is that most, what I found, most divorce cases are now not so much based on the divorce grounds discussed in the Undang-Undang Perkawinan, in the penjelasan of the divorce grounds of the Undang-Undang Perkawinan, but more about the jurisprudensi MA, which established that it's not the task of the court to establish whether one of the parties is at fault in the marriage, but only whether the marriage is broken beyond repair. So what is happening is that more and more the judges only investigate whether a a marriage is broken or not, and not base themselves on the original grounds which are mentioned in the marriage law and the government regulation about the marriage law. So one typical case is for instance that the refusal by the wife to withdraw a divorce petition is already proof that the marriage is broken. So that was for the Pengadilan Agama in Cianjur, that was enough grounds to sustain a divorce petition. Now, I also found the opinion which considers that the ease by which now divorces are granted by the Pengadilan Agama has caused some unease in relation to the feeling of justice. So, because in some cases, such as, for instance, domestic violence or neglect of the wife, it might be in the interest of the victims to establish who is at fault actually for the broken marriage. But in those cases, the judges still refuse to say that one party is at fault if the case is based on Pasal 19F ya percekcokan. And so one of the things is that that often sometimes cases are related to domestic violence, and there is a feeling that some judges are not so sensitive about this and just treat every case as if it's a similar one in which they only have to establish whether a marriage is broken beyond repair or not. Now, I believe that in some cases it is in the best interest of the child to consider at least the fact that that the husband, for instance, is accused of neglect or of violence, because it also has repercussions for the further life of the child, and that brings me. I will come back to this later. Now, registration in the best interest of the child. Well, after the controversial decision of the Constitutional Court, which amended Article 43 of the marriage law to include, which states that children born out of wedlock only have a civil relationship with the mother, but it was changed to the father in case it can be proven that scientifically that it is indeed the father of the child. The Rapat Pleno Kamar Agama came together and in this meeting, the Mahkamah Agung stated, you can find it online, this document. They wanted to increase the grounds for isbat nikah, so for registration of an existing religious marriage, to include the purpose for registration of the children. So in the I think that there are only 5 reasons for 5 grounds for to register for the court to register an religious marriage, so isbat nikah, which are, I think, if the if the marriage was conducted before 74, so before the marriage law, if the marriage certificate is damaged or lost, and for reasons of divorce, so to divorce out of a religious marriage, you can register it first, so you have the possibility to divorce from. And now that this is included, that for the purpose of the registration of children, you can also do isbat nikah. Well, I found some isbat nikah cases which were related to the registration of children born into that marriage. And this was one case in which, so it's a nikah siri. This is about unregistered marriages, only religious marriages, informal. I don't know, informal is a bit controversial term, so I used the term religious marriages. But in this case, it appeared that the wali did not fulfill the qualification of the wali. So the marriage was declared void. But the children were still considered as legal children, anak-anak yang sah, and also registered as legal children. But they did not base themselves on the marriage law, which I found very interesting, but on the child protection law, the judges, among others. And Article 7 and 14 are about the right of the child to know be brought up by their own parents. So that was an interesting case. What we also see in child registration is, and also related with nikah siri, is that now the father of a child born into nikah siri, so in an unregistered marriage, can be included in the Kartu Keluarga and birth certificate, which I think has some consequences. It is some kind of a recognition of the validity of nikah siri beyond the recognition that was already established by some jurisprudency of the Supreme Court, by some case law of the Supreme Court, because it goes further. It is the father can now be mentioned into a Kartu Keluarga. And so in some cases, also in the birth certificate, but I think the practice in Indonesia is not uniform yet. So concerning this, what you need is a surat penyatakan tanggung jawab mutlak from am I already too late? From the RT or the RW. So a statement of the local neighborhood head, or how you would call them, that indeed these persons are married religiously. That can then be the ground to register, to be registered in the family card. Also the father, in cases of nikah siri. And this is quite a shift from the discourses in 2010 when there was a draft law on the hukum material. What was it? KHI or something like that. Nee, hukum material yang berlaku di peradilan agama or something like that, in which there was a trend in the discourses that I found online to criminalize nikah siri, and now there's actually accommodation of nikah siri, so that is quite a different it's different development than I thought Indonesia was heading in 2010. So it's the opposite from criminalization, which was in the air. It became accommodation of nikah siri. And then related to the Constitutional Court decision, there are some judgments by religious courts in which children that actually are not born into marriage, but were born before the marriage, so outside of the marriage, and then the parents married and asked whether their children could be legitimized. Well, in these cases, the judges had to establish their asal usul, so the origins of the child in Indonesia, and they decided not to describe the child as an anak sah, but as an anak biologis from of his father. So in 3 cases, I found this. I don't know if more recently there are. I heard that this idea of anak biologis has been denounced, but I haven't. I haven't got information whether indeed the practice of establishing children or as anak biologis has stopped at the lower court, so the first instance religious court. Now, one of the issues which I was part of my dissertation was anak and the child supporter. I found there are no clear standards of how to establish the amount of child support. And more specifically, I found that courts often follow the statement of the husband about his capacity to provide. So he says, I'm only capable of providing 1 million, for instance, 1 million rupiah per month. And the wife says, no, I know you are capable of paying me 3 million. But the court has the tendency to follow the husband because the wife cannot prove that the husband has the capacity to pay more than this. So, but there are no clear standards. It's all decided according to the discretion of the judges, which I think perhaps it would be a good thing if some standards would be developed here. Another thing is that enforcement is problematic, and one of the issues is that there is a Supreme Court decision that has said that due child support is unpaid child support is not considered to constitute a debt. So in this case, a wife wanted to suit or made a counterclaim to her husband that he still had to pay her
Yeah, we are
a certain
sorry,
amount of
Professor
child
Tim,
support.
because
Now we have Friday prayer in Indonesia. So
Yeah. Okay.
almost all the participants, mostly males participants, will go to Friday prayer. Maybe you can shorten your presentation.
Okay.
Yeah.
Okay.
Thank you. I'm
Well,
sorry
then
about
I
that.
will. The problem with the wife is the same support for the wife. So nafkah, ida, mut'ah, and kiswah. There are no clear standards. Judges sometimes request payments prior to establishing the date for the ikrar talak, so for the pronunciation of the talak. It's a pragmatic solution, but legally problematic as the marriage has not been dissolved yet at that moment. So it's still possible that the husband will change his mind, for instance. Another thing is the possibility to grant nafkah, ida, mut'ah, and kiswah in gugat cerai cases, so cases petitioned by the wife. Normally, if in the gugat cerai cases, cases petitioned by the wife, she will lose her rights on nafkah, ida, mut'ah, and kiswah. But it was discussed within the religious courts, I found through interviews, that if the husband is clearly at fault for the divorce, or perhaps had divorced the wife already informally, so cerai liar, cerai di luar pengadilan, that in fact maybe a wife should have the rights of nafkah, ida, mut'ah, kiswah. But the discussion in 2011 has not resulted in any new jurisprudence, I think, and it was not followed up by the Mahkamah Agung. There is a judgment by the High Court of Surabaya, which I mentioned here, in which the court decided to grant a wife in a gugat cerai case to grant her nafkah, ida, and mut'ah. The other thing is about joint custody. The main thing which I want to discuss is that during the mediation, it's now possible to discuss more things than only reconciliation, right? So you can discuss the future of how you will divide the marital property and so on and so on. So now I know that there are people who are pushing to make this into some kind of the mediation process into some kind of a moment in which the parents can discuss a parenting plan, so custody of children, child support, but also agreeing about where the child will stay, whether one of the parents will have custody of or they have joint custody. Decisions about the upbringing of the child and so on can be discussed. In the Netherlands, this is mandatory. It's wajib, yeah, to have a parenting plan before you divorce. And yeah, it's an idea that also it has been taken up activists in Indonesia. Ada anak angkat. Only anak angkat adoption. There are two types of adoption in Indonesia: formal adoption and customary adoption. And customary adoptions are not regulated, and everything when they come before a religious judge, they have a lot of discretion to decide whether the procedures of formal adoptions apply to customary adoptions as well or not. So it's not clear, and I think it would be a good thing if there would be some new regulations about customary adoptions. What are the procedures to acknowledge, to legitimize customary adoptions at the religious courts? Okay, I think these are the references I used, and thank you.
Okay, thanks a lot,
Yeah.
Dr. Steen. We are sorry because today it's Friday, so most of them are going to the mosque for Friday prayer. But it's
Yeah,
okay. It was a very interesting topic because you are putting in the table the remaining problems within our Islamic family law in Indonesia, for example, about joint custody. Before, there was a question about joint custody in Indonesia, and maybe you can compare to Netherlands case. The question was, is there any age requirement to determine whether the custody will go to mother or father or both? So maybe you can give us some insights about the differences between Indonesia and Netherlands about the age requirement for children to go to custody.
Well, in the Netherlands, there is a preference for joint custody, actually. But even if one of the parents is granted full custody, it doesn't mean that the other parent doesn't have the rights to decide things together with the other parent about how about the upbringing of the child. So the right of the parents, although one of the parents has custody, the right of the other parent is not fully how do you call it? Dihapus, yeah, not fully
eradicated.
wiped away.
Yeah.
About the age, yeah, in Indonesia you have the 12 years rule, right? That below 12 years, in principle, the child will the custody will be accorded to the wife, and above 12, the child will have a say in in whether the wife or the father, the
husband,
father or the mother will have. In the Netherlands, there is always the child is always involved. Only in the decision. Only yeah, if the child is 1-2 years, it's impossible, right? But then there also is a preference to give custody to the mother if there are no issues with her, well, like if she neglects the child or something like that. Sorry for my voice, but I think that the idea that is being developed. I think that that a parenting plan can be drawn up during the mediation process. I think that would be a good thing. Because in many cases, the problem is in divorces in Indonesia. In many cases, one of the parents is not present. It's almost all are in absentio, all the divorce cases, and there is almost no so if there are children involved, actually, I believe that the in absentio rule maybe should be sharpened, or as the child can divorce doesn't only involve the husband and the wife, but also the children.
Of course, yes.
They
are the
and I sometimes and in many of these cases only one of the parties is present, and you don't get in the mediation phase a good discussion about what the child wants, or whether the child still wants to have a good relationship with the father or the mother, if it's and so on. And yeah, I think that in the best interest of the child and the right of the child to be brought up by both parents, which is now a part of the Undang-Undang Perlindungan Anak, Article 7 and 14. I think it would be good if this would be taken into consideration and in divorce cases. So the position of the child.
Yeah, I hope so. The best interest of the children, not only in the case of divorce, but also, for example, in the case of polygamy, because sometimes people don't think further about how polygamy can influence the welfare of the children. Okay, Dr. Steen, actually we want to extend the time, but because, actually we have time until 12 today, but we are ahead of time, 15 minutes. So I, as a moderator, will say thanks to all the speakers today. Pak Dr. Chris, Pak Dr. Steen, Professor Khairuddin, Ibu Dwi, and also Dr. Iwan. Thank you for a very good discussions today. We have so many topics in Islamic family law, also in international family law from various perspectives. Again, I'm as a moderator, please forgive me for maybe technical issues, technical problems, and also any other issues that we are facing today. So I will close this discussion by saying Alhamdulillah, and again, thank you so much to all our speakers. We will see you next time in another discussion, daring or online or offline. Thank you, Pak Dr. Chris, Pak Dr. Steen, Professor
Thank you so much.
Ibu Dwi dan Ibu Iwan. I think Professor Khairuddin is not here anymore. Okay. Yeah, I will give back the microphone to MC, Master of Ceremony.
Yeah. Thank you very much to Ms. Atun, Dr. Atun Wardatun, MAG, MA, PhD. Thank you very much. Thank you for Mr. Dr. Christopher Kassan, Mr. Dr. Chin Van Huis, Professor Dr. Khairuddin Nasution, MH, Mr. Dr. Iwan Oral Yosef, and Ms. Dr. Dwi Arianti, MH. That's closing our international conference today. Inshallah, we will start on Saturday morning. Thank you very much. Wassalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam warahmatullahi wabarakatuh.
Makasih Bu Alia, Bu Atun. Ini di sini sudah azan nih, jadi kita lari lagi. Makasih banyak.
Terima kasih Pak, terima kasih. Alhamdulillah.
Terima kasih ya, Prof. Alim.
Pak Steen, thank you Pak Steen.
Ya maaf sekali ya, saya bikin double agenda ini, maaf sekali saya. Ya.
It's okay, we know you are very early in the morning now in Netherlands. Okay, thank you.
Terima kasih Bu Atun. Nah.
Ya, sama-sama Pak.
Iya, Bu Umi ini serius banget dari tadi saya lihat. Kameranya hidup terus tuh Bu Atun. Kita seminar di Madura lagi ah.
Ayo.
Terima kasih.
Monggo Pak. Pak Alim.
Terima kasih Bapak dan Ibu.
Sama-sama. Terima kasih juga ilmunya.
Kita lari sholat Jumat dulu nih Bu Umi.
Ya, monggo, monggo.
Ibu Umi, insya Allah nanti besok kan Bu, lagi.
Ya, kita besok mulai jam 8 ya Bu Halia.
Di sini di saya jam 7.30.
Oh, 7.30 ya.
Nah, tapi ya tidak tahu lah apakah ini on time.
Iya, di kelompok berapa?
Di sini hanya tertulis jam 7.30 registrasi peserta melalui Zoom. Kemudian langsung klaster 1 jam 8.00.
Kayaknya bareng ya Bu, klaster 1, 2, 3 itu bareng ya?
Dengan 3 Zoom.
Iya, 3 Zoom.
Sampai klaster 4 kan Bu?
Oh, sampai 4. Oh iya.
Ibu ada Bu sebagai presenter ya?
Iya, di klaster 3 kalau nggak salah.
Mohon izin ya Bapak Ibu, saya mau sholat dulu. Terima kasih banyak semuanya. Assalamualaikum.
Waalaikumsalam.
Terima kasih.
Makasih. Mama.
Di klaster 3 perlindungan hukum terhadap anak akibat ditolaknya permohonan isbat nikah Bu ya?
Iya.
Oh iya, klaster 3.
Klaster 3. Mulainya bareng ya Bu?
Jamnya kalau klaster 3, oh klaster 3 saya yang moderator Bu.
Kita satu klaster Bu Umi ya?
Iya, kita satu klaster. Bareng kan itu? Mulai jam 8 ya?
Jam 8 Bu, kalau jadwal dari jam 7.30 registrasi sampai jam 12.30 Bu, selesai.
Oh 7.30 ya?
Sampai 12.30. Oke. 12.30 ditutup oleh Pak Prof. Banyak juga Bu makasih. Yang masuknya.
Monggo, assalamualaikum.
Waalaikumsalam.